All right, let's get right to it. Today, we are taking complete control over one of the absolute most formidable subjects in law, the Code of Civil Procedure 1908 and the Limitation Act. Think of this explainer as your definitive, chronological journey through the entire life cycle of a civil suit. We're going to strip away the confusion, cut through the noise, and map out exactly how a case moves from being just a mere grievance to a final executed decree. And to make sure we're keeping things as precise as possible, we'll be keeping all our key legal terms strictly in English. Let's get started. Okay, let's dive into this. We've got 5 distinct phases on our agenda today. First, instituting the civil suit. Second, pleadings and dispute framing. Third, trial and execution. Fourth, special suits and appeals. And finally, phase 5, which is all about the clock, the Limitation Act. All right, kicking things off with phase 1, instituting the civil suit. Look, every single civil suit is born from a cause of action. That's basically a bundle of facts that gives you the actual legal right to sue. On one side, you've got the plaintiff. That's the person who kicks off the whole process by presenting a formal document called a plaint. On the flip side, you have the defendant, the person standing on the other side of the ring, the one against whom relief is sought. Obviously, you've got to have both if you want to have a fight. But here's the thing. You can have a totally valid cause of action, but if you walk into the wrong courtroom, yeah, your suit is dead on arrival. You have to satisfy 3 pillars of jurisdiction. First up, pecuniary jurisdiction. Basically, is the financial value of the suit appropriate for this specific court's grade? Second is territorial jurisdiction. Does the property actually sit within this court's geographical boundaries, or did the cause of action even arise here? And third, subject matter jurisdiction. Is this a general civil dispute, or is it reserved for a special tribunal, like a family court? If you want to proceed, you absolutely must align all 3. Now, even if you nail the jurisdiction, the CPC steps in to prevent complete judicial chaos using 2 massive doctrines. On one side, we have sub judice under Section 10. This kicks in when a suit is currently pending. If you try to file a parallel suit on the exact same issue between the exact same parties, that second court will strictly stay its hand. On the other side is res judicata under Section 11, which literally translates to a matter decided. If a competent court has already heard and finally decided the issue, you are barred from relitigating it. So think of it like this. Sub judice hits pause on the game, but res judicata ends it entirely. Which brings us to a really landmark case, Darial v. State of UP. Let's break this down using the FARAC method. The facts? Petitioners filed a writ petition in the Allahabad High Court, and it was dismissed on its merits. Unhappy with that, they bypassed everything and went straight to the Supreme Court under Article 32, raising the exact same issues. So the massive issue before the Supreme Court was this: does the strict civil principle of res judicata actually apply to constitutional writ petitions? And here is the crucial takeaway from the Supreme Court's ruling. They basically said, look, res judicata isn't just some minor technical rule. It's a fundamental principle of jurisprudence based on the absolute finality of judicial decisions. If a high court decides a matter on its merits, you don't get a second bite at the cherry by filing a fresh writ. No way. The door is firmly, permanently shut. Moving right along to phase 2, pleadings and dispute framing. There's a very logical, honestly unyielding progression here. Step 1 is the plaint under Order 7, where the plaintiff formally states the material facts and the exact relief they're claiming. Step 2 is the written statement under Order 8. Here, the defendant must specifically deny the allegations within a strict 30-day window. And keep in mind, an evasive denial is legally treated as an admission. Finally, Step 3 is the framing of issues under Order 14. The court reviews the plaint, reads the written statement, figures out exactly where the parties are clashing on facts or law, and then frames the precise issues that will actually be tried. But hey, what happens if you make a mistake in your pleadings? Well, that exact question was tested in Salem Advocate Bar Association v. Union of India. See, the CPC was amended back in 2002 with a super strict rule restricting parties from amending their pleadings once the trial had actually begun. The Bar Association challenged this. They asked the Supreme Court, doesn't this strict cutoff violate the fundamental right to a fair trial by stopping the whole truth from coming out? The Supreme Court laid down a really commanding rule here. They upheld the amendment, stating that courts have to balance complete adjudication with expeditious disposal. Their logic? Before the trial begins, courts should absolutely be liberal in allowing amendments, but after the trial starts, the door closes. The only exception is if the party can pass a strict due diligence test, proving that absolutely, positively could not have raised the matter earlier. In other words, the old "the dog ate my homework" excuse won't cut it. Dilatory tactics will simply not be tolerated.
All right, that brings us to phase 3, trial, judgment, and execution.
Once the dust settles and the trial wraps up, the court delivers its decision. Now, you absolutely must distinguish between these two English terms. A judgment is the reasoning. It's the detailed statement given by the judge outlining the specific grounds for the decision. The decree, however, is the operational document. It is the formal expression that conclusively determines the actual rights of the parties. So remember, you appeal against a decree and you execute a decree. And execution? Well, that's where the raw power of the state is unleashed. Under Order 21, which, by the way, is the longest and most detailed order in the entire code, the decree holder forces the judgment debtor to comply. Section 51 provides the arsenal. The court can order the physical delivery of property. It can attach the debtor's property and sell it at a public auction. It can even order the arrest and detention of the debtor in a civil prison for unpaid money decrees. Or it can appoint a receiver to manage the assets. The bottom line? The court ensures its decree is not just a worthless piece of paper. Which brings us to a highly tested, really interesting area. Hari Shankar Paul v. Anaf Nath Mitra. Imagine a judgment debtor who loses the trial, doesn't appeal, but then tries to argue during the execution phase that the original decree was wrongly decided. The paramount issue here is, can an executing court go behind the decree and reopen the merits of the original dispute? This brilliantly illustrates the strict boundaries we're dealing with. The Privy Council gave a definitive no. The executing court must take the decree exactly as it stands. Its sole exclusive function is enforcement, not relitigation. Now, the only exception is if the decree is a fundamental nullity, meaning the original court completely lacked jurisdiction. Otherwise, the executing court will shut down any attempt to reopen the facts in a heartbeat. On to phase 4, special suits and appeals. Guys, there is a massive difference between a first appeal under Section 96 and a second appeal under Section 100. In a first appeal, the appellate court acts almost like a trial court. It can completely reappreciate all the evidence. Both questions of fact and questions of law are wide open for debate. But a second appeal to the High Court, the doors are heavily restricted. Evidence cannot be reappreciated and facts are generally locked in stone. To really cement this concept, let's look at Pandurang Mandalek vs. Maruti Hari Jadhav. In this case, a plaintiff filed a second appeal. Both the lower trial court and the first appellate court had already agreed on the facts. These are what we call concurrent findings of fact. Yet, the High Court intervened and reappreciated the evidence anyway. The Supreme Court had to step in and answer. Does the High Court actually possess the power to do this in a second appeal? The Supreme Court's ruling, it was an absolutely unforgiving directive. Under Section 100, a second appeal lies only on a substantial question of law. Concurrent findings of fact are absolute and conclusive. The High Court cannot touch them, even if it completely disagrees with the lower court's assessment. The only exception is if the finding is entirely perverse and based on zero evidence whatsoever. Otherwise, the law is literally the only playground left at this stage. Finally, Phase 5, the clock, meaning the Limitation Act. The governing maxim here is vigilantibus non dormientibus, jura subvenient. Simply put, the law assists the vigilant, not those who sleep on their rights. If you suffer a breach of contract or someone defaults on a promissory note, you have exactly 3 years to file a suit. If you're dispossessed of immovable property, you have 12 years. And here's the kicker. If you file even one single day late, Section 3 of the Act mandates that the court must dismiss your suit. Your substantive right might technically still exist out there in the ether, but your judicial remedy, it's permanently extinguished. But is the law really always that heartless? Well, for appeals and applications, now note that's not original suits, just appeals and applications, Section 5 allows the court to condone the delay if you can show sufficient cause. In a landmark case of Collector v. Mahest Khatiji, the Supreme Court laid down an incredibly important, justice-oriented approach. They declared that courts actually need to be liberal here. When substantial justice and technical considerations are pitted against each other, substantial justice has to win. Yes, you must explain the delay, but courts shouldn't take a pedantic approach that sacrifices fairness at the altar of technicality. Which leaves us with a really profound tension to consider as we wrap up this explainer today. The courts frequently declare that procedure is merely the handmaid of justice, meant to facilitate the truth, not obstruct it. Yet, as we've just seen with the harsh guillotine of the Limitations Act and the unyielding rules of res judicata, the law heavily prioritizes ending disputes once and for all. So, I'm going to leave you with this provocative thought to debate. Does a strict limitation period actually serve true substantive justice by forcing people to be vigilant, or does it merely serve administrative finality? Keep that tension in mind, stay focused, and I will see you in our next explainer.